A brief introduction to international law. International law entails the body of rules and principles that are established through customs or treaties and accredited by nations and international organizations as binding in their interactions with each other. International law is not a world law but instead is a law that exists between compliant sovereign states, with each nation having the liberty to choose the laws it wants to adhere to. Despite its limited capability, the law has, however, been instrumental in the development of a system of both procedures and rules in various aspects of human needs, such as establishing human rights. International law differs from the federal law in various ways. In the U.S., both the state and federal governments are charged with the enforcement of American domestic law. When it comes to international law, however, neither the government nor the international organizations can enforce it. International law also differs from federal one in that international law consists of conventions, treaties, and charters that come into play only with the mutual approval of the contracting nations or international organizations. Federal laws, on the other hand, are only acknowledged by the legislature of the respective federal or national government. Examples of international law include the Universal Declaration of Human Rights, which was adopted in 1948. The law stipulates the entitlement of freedom and the right to the protection and promotion of human rights worldwide. The Vienna Declaration and Program Action of 1993 reaffirmed this law with emphasis laid on the integration of economic, cultural, and social rights in addition to civil and political rights. Another example of international law is civil and political rights for all. This law was first adopted in 1966 during the International Covenant on Civil and Political Rights. The law stipulates that the rights acknowledged in the covenant are respected and preserved without any discrimination whatsoever, be it of race, sex, color, religion, language, political, national, or social origin. The law further requires that parties entitled to ensuring equal rights to all facilitate the realization of these rights. As such, all persons are considered equal before both the courts and tribunals. International law originates from various sources ranging from international agreements, resolutions passed by international organizations, customary laws, and decisions by international tribunals and courts, treaties, and some general principles of the law. As such, international agreements, treaties, conventions, and protocols between states are considered the oldest sources of international law. Customary law is developed by states after adhering to certain customs that all parties must remain obliged to. As such, the international community is in many cases involved in the creation and formulation of these laws. The international community facilitates this by the development and signing of covenants between member states on how to deal with arising legal challenges among them. The United Nations also plays an essential role in the development and enforcement of international law. In this regard, among the many objectives of the UN is to establish conditions through which the facilitation of both justice and respect concerning the obligations that arise from treaties, together with other sources of international law, are maintained. The UN is not only a forum for discussion on international matters among nations through its various organs, but it is also an instrument that facilitates multilateral peacekeeping, in addition to the promotion of social, economic, and political goals. This is the UN's vision of progressive development of international law in areas of dispute resolution. If international law is enforced in a world without central government authority, it can still be enacted in different ways. As such, the United Nations Security Council, which is tasked with maintaining security internationally, has the power to enforce international law through ways, such as an imposition of economic sanctions and severe diplomatic relations.